Unmute, a rookie mistake. Welcome everyone. It would be good morning and good afternoon and good evening to you all. It is lovely to see you back here today. We want to just remind you that the opening session of the series that was recorded last week will be made available on the SOF Heyman YouTube channel this week or the next week. And I believe we will circulate a link in the chat. And so we also just want to touch on a few things. So we have received a few emails asking about the ongoing graduate worker strike at Columbia. And so we want to share a few provisional remarks on it, and thank you all for your concern. So at our university, we have been organizing for a union and a student worker contract with the Columbia administration for 5 years. Without a contract, graduate workers such as myself and Howard Taylor are exposed to Columbia's uneven and unfair approaches to handling employment. And so it has taken the university 3 years to join a bargaining table, and we have now been at this bargaining table for 2 years. The article on non-discrimination and harassment has emerged as the great ideological sticking point of the contract. The university does not want to provide a third-party arbitration access to students, even while we are also workers. This is quite unusual. For this reason, we are now on the 8th day of striking from our labor as graduate workers. Over the last 3 years, we have been on a total of 3 strikes. And so we encourage you to familiarize yourself with the work of our union, and in particular with the Hardship Fund. For anyone with additional questions, please do get in touch with us at our email opir2020@gmail.com. Howie will circulate the email in the chat box. And for questions, including on how you can support the strike and the Graduate Workers Union, there is also a link that will be circulated on the website, the Graduate Workers website. Moreover, for those of you who may be wondering why we're not canceling this seminar series, we want to share that as per the union, quote, student workers should continue their academic progress while striking. Refusing to attend your classes as students is not legally protected. You can see more about this in the frequently asked questions on the Graduate Worker at Columbia website in the FAQ. So the legal distinction here is between graduate workers and graduate students. So as student workers, we do not have legal or academic protection if we refuse to go to our own classes, which here includes scholarly related labor such as conference organizing, research, etc. In the case of this conference, it means that we have no financial protection from the union if we cancel the series. We are currently investigating whether we can move the meeting off this Columbia-sponsored webinar certificate to a regular Zoom link without jeopardizing our funding, and we will keep you posted. So, and also last thing, we have been in ongoing conversation with union representatives this last week and over the weekend, and they affirmed their support for our decision and told us, quote, using the conference to lift up the strike would be more effective for visibility than canceling it, unquote. It's logistically and practically complicated, to say the least, and do reach out if you have questions. So back to our event today, where we are excited about the panel Reparations on a Global Scale. The structure is as follows. Each presenter will give a paper for about 15 minutes. Each presentation is followed by a question from our panel moderator, Dr. Perry. And after all presentations, Dr. Perry will open up the floor for a Q&A. Dr. Keston Perry is a political economist and interdisciplinary scholar at the University of the West of England, Bristol. He's been carefully invited or chosen to lead this panel because of his expertise. His work examines climate justice and reparative frameworks for utilizing subversive methodologies, colonialities of development finance, and international climate policy in the global South. His scholarship appears in a number of international peer-reviewed journals, as well as in popular outlets like The Guardian, Al Jazeera, and The Nation. Dr. Perry was previously a postdoctoral scholar at Tufts University and served as an external advisor to the United Nations Development Program. Last year, he completed a policy report on climate reparations for the United Nations Association of the UK as part of negotiations at the 75th anniversary of the UN General Assembly. Dr. Perry, thank you so very much, and I'll hand it over to you. I'll just chime back in. Dr. Perry, did you receive my handover from before?
Yes, no, I did not. So I think I'm having a problem with my connection, my Wi-Fi connection. So I'm calling you from my mobile phone. So let's hope that it works.
Okay, that's excellent. Fingers crossed for that. But please do take over. The floor is yours. Thank you.
Thank you very much, Anna and Howie. Thank you both for organizing this. And we do recognize and acknowledge the strike action that's going on by Columbia graduate student workers. And we do, as much as we can, support and stand in solidarity with them. I would now first begin our conversation and our discussion today by reflecting on a couple points with respect to some of the contributions that you're about to hear. I think it's really important for us to have this conversation at this present time in the global political economy, and based on reverberations we've had over the past year of global uprisings with respect to Black Lives Matter, and with respect to bringing forth issues around reparatory justice and the reparative frameworks that we think are really relevant and important to bring justice to the lives of people of African descent and to people who have been in marginalized positions across the globe. So I'm really grateful for this opportunity for us to have this conversation. After our panelists have spoken, we'll have some time for questions from the audience. You should see a Q&A box on your screen at the bottom and the middle of your screen, where you can submit your questions for me to read out loud. We may not get to all of your questions, but we will try to get our best to get to as many as possible. Panelists, I'd first like to introduce Vasuki Nasaya. Vasuki Nasaya, who will be our first speaker, is a professor of human rights and international law at the Gallatin School, New York University, and writes on the history and politics of human rights, humanitarianism, international criminal law, global feminisms, and decolonization. Her paper today is part of a book project called Reading the Ruins, Slavery, Colonialism, and International Law. You have the floor, Vasuki. Thank you for coming today.
Yeah. Yes, sorry, as usual, I forgot to unmute. Thank you very much, Keston, and my thanks to Anna and Howie for the invitation to be part of this conversation, and Keston for so generously reading and responding to a paper that you just received on Sunday. So many thanks. I want to express solidarity with the graduate student strikers and the complicated decision to participate in an event that is itself organized by graduate students. There's no clean call here, and by participating, we are sort of enjoined to support the strikers in any way we can. I hope the university will respond positively to graduate student demands. As Keston mentioned, the paper I'm presenting is part of an ongoing larger project. This particular chapter is the chapter that draws from, speaks to, and learns from legal scholars such as Robert House, but it also speaks to and learns from scholars in other disciplines such as Saidiya Hartman. All to say that this opportunity to engage in an interdisciplinary conversation is especially valued. My talk today is really a question about how we might surface the interruptive capacity of recombinant legal narratives. Can the archive of legal principles be seen as a toy box for counter-memorial readings of international law, or what some might describe as a reparative reading of international law? Dominant readings of international law celebrate its provisions for victims' right to reparations. Situated within the international human rights framework, the recognition of a right to reparations is in response to human rights violations, is often framed in terms of international law's promise for progress, for generating and buttressing norms, laws and institutions that provide ameliorative closure on these histories of atrocity. Indeed, it is often a piece with a reading of atrocity as itself arising from the violation of the rule of law, rather than being symptomatic of the rules of the game. Against the backdrop of that dominant narrative, I read the archive of international law against itself. There are different ways in which to enact such a counter-reading, but in the context of our discussion today, I want to focus particularly on the potential work of international legal concepts in relation to demands for reparations, and in particular to probe the notion of odious debt in relation to the demand for the severance of sovereign debt as one form of reparations. Focusing especially on Haiti, I want to suggest that odious debt is a generative lens through which to rewrite the contract between Haiti and France, or we might say between Haiti and the international community, because that contract was inextricably tethered to the histories of colonization and slavery. Rather than think of reparations as a way of giving colonialism and slavery their rightful place in the history of international law, this is more a project of counter-memory, taking a concept of international treaty and contract, namely odious debt, and retrofitting it in the conversation about reparations. I find Fred Moten and Stefano Hani's approach to the notion of a toy box useful here. In a toolbox, a screwdriver is a screwdriver. But in a toy box, you may take a cricket bat and treat it like a sword, or you may take your chess pieces and play checkers with them. There is, in other words, an invitation to misuse, to push against closure, to subvert the ends for which a legal concept was developed. The impulse may seem mischievous, not as being frivolous, but as being disloyal to the rules of the game. I want to draw out these recombinant legal narratives and probe the potential of this play. In the three sections that follow, I first remind us of the Haitian debt context, then move in the following section to say more about the concept of odious debt, and probe what work it could do in relation to a Haitian reparation claim for sovereign debt severance. And finally, I return to the interruptive capacity of reparative claims and the ways in which we might put international law into play in contesting the rules of the game. So let me begin with Haiti, or what a section I title Haitian Sovereignty and Debt Bondage, the Shackling of Freedom and Unfreedom for International Recognition. So let's begin then with the genesis of the Haitian debt. This takes us back to the Haitian Revolution of 1804 and the 2 decades that followed, when France relitigated the Haitian victory in the domain of law and debt. Empowered by the inter-imperial alliances sealed at the Congress of Vienna, France and her allies would not grant recognition to the Haitian Revolution and recognize Haitian sovereignty unless Haiti agreed to pay France the princely sum of 150 million francs as indemnity for the financial loss incurred by France and French slaveholders as a result of Haitian emancipation. With French warships looming on the horizon and hungry for the international recognition of sovereignty, post-revolutionary Haiti agreed to these conditionalities and took on that indemnity as a debt to France. In exchange, the international community then recognized Haiti as a sovereign nation in 1825. There was a world of difference that came between 1804 and 1825, between revolutionary Haiti and post-colonial Haiti. And that's in a way the subject or the takeoff point from my discussion today, those 20 years. To render itself visible to the world and earn recognition as a free and independent sovereign, Haiti was coerced into contorting itself into a debtor nation in the ledgers of international law. Paradoxically, this required asserting Haitian sovereignty in the very act that corroded it, namely accepting the terms of the extortion as debt. In the international public sphere, sovereign debt interpolates financial burdens as a self-inflicted wound undertaken by free and independent nations. The act of assuming indebted status, this act of a sovereign nation, is then the very process that births Haiti's inclusion in the supposedly universal category of sovereignty that earns recognition in the society of nations. The stealth work of post-colonial sovereign debt, however, is that it impairs and fetters sovereignty in the process of enabling recognition. Haiti incurred further debt to keep up payments, and even after total amount was renegotiated to 19 million francs. Haiti finally paid the principal indemnity 6 decades later, in 1893, and settled all accounts, including related interest payments, in 1947. The category of debt works to focus our attention on the obligations of the indebted, rather than the coercive world order that births and sustains that status. This scaffolds the political horizon of independent Haiti, where the responsibilities attached to debt present as an indicator of Haiti's sovereign agency, even while it is a vehicle for greater and greater sovereign dependence. Today, Haitian national debt is in the order of $3.5 billion, about a third of its GDP. Some Haitians, most prominently perhaps former President Jean-Paul Aristide, have demanded restitution of the indemnity funds as reparations. This demand is an important adjunct to the CARICOM plans for reparatory justice, which calls for rewriting sovereign debt as one point in its 10-point plan for reparatory justice. Implicit in this vision is an analysis of how histories of colonialism and slavery are windows to the past, but also constitutive of the present. The Haiti indemnity story is a synecdoche of that larger regime of world economic order built by colonialism and slavery, and concomitantly, that larger landscape of post-colonial sovereign debt. Okay, so we turn now to the concept of odious debt. So the concept of odious debt has emerged in a different sphere, in the sphere of development, has emerged in contemporary context of political transition to argue for the termination of debts undertaken by a previous odious regime. As elaborated by legal scholars such as Robert House, the rationale is that if a debt is taken on in circumstances that are odious, often because the actors involved do not legitimately represent the nations on whose behalf they are taking on the debt, then when there is a political transition, a legitimate successor state can terminate that debt. The core insight of the notion of odious debt is a simple common law principle of equity, i.e. that the party's submission to a contract is not proof of its validity. The validity of contract should also depend on the basic principles of fair, equitable, and non-coercive conditions. In this case, the world order built by colonialism and slavery was effectively a party to the treaty acquiescing to the indemnity post-revolution, a co-sovereign of the post-colonial nation state enacting debt, thus rendering that regime and the debt incurred odious and therefore illegitimate. Accordingly, when Haitian sovereignty emerged into the Society of Nations in 1825, already indebted, it was the emergence of this odiously twinned regime that led to both the acquisition of debt and the negotiation of its terms. In foregrounding this twinned regime, the concept of odious debt makes debt severance legally legible. It interrupts the progress narrative of international legal recognition by telling a story about how Haitian sovereignty can earn that recognition only as always already fettered. If 1804 marked the birthing of a revolutionary Haiti, then the 1825 recognition of Haiti as an already indebted sovereign nation is in many ways the origin story of post-colonial sovereignty. Midwifed in the world by the twin forces of revolutionary aspirations for freedom and odious debt, the key foundation of post-colonial sovereignty is that shackling of freedom and duress. Reparations claims have a constitutive performative structure, where the telling itself interrupts how the world functions. They foreground historical legacies and present conditions to expose, to lift the veil, to reveal facts. Yet, as Eve Sedgwick reminds us, there are political limits to the hermeneutics of exposure and suspicion. The interruptive, unsettling work of reparations claims is not just making past horrors of present inequalities visible, but making us attend to the act of seeing. It is a reminder that all of this is already visible. This is the power of noticing, seeing, and unseeing. They call attention to the scandal of that visibility. The structural arrangements linking globalization's winners and losers are hiding in plain sight, and reparations claims are ensuring that we trip over what is in front of us when we would rather walk around it, interrupting international legal narratives of freedom and progress that are also histories of enslavement and fettered sovereignty. Rewriting debt as reparations is not a bookkeeping intervention, but a political one. As Robert House notes, odious debt entails a fundamental reframing. He says it regroups a particular set of equitable considerations that have often been raised to adjust or sever debt obligations in the context of political transitions, based on the purported odiousness of the previous regime and the notion that the debt it incurred did not benefit or was used to repress the people, close quotes. In the Haitian case, this reframing enables a revisiting of 1825 in the spirit of 1804. 1825 cemented a compact where Haiti severed the radical aspirations of 1804. Thus, when France formally renounced its claims to Haiti, what it recognized was the post-colonial sovereign state, not the revolution of 1804. In turn, Haiti's reparations call is a successor to the revolutionary spirit of 1804, rather than the sovereignty recognized by the Society of Nations in 1825. Yet many cases where the doctrine of odious debt has been considered, post-apartheid South Africa, for instance, the international community has urged against it, advising that reneging on debts undermines the bona fides of the debtor nation, deterring foreign investors looking to make an honest deal, and inhibiting integration into the international economic system. Instead, multilateral institutions encourage continued debt servicing to earn recognition for good financial citizenship in the international economic order. International law's membership rules have embedded in them hierarchies and exclusions that make the quest for recognition a tragically self-defeating enterprise. As Anthony Engie argues, international law presented non-European societies with the fundamental contradiction of having to comply with the authoritative European standards in order to win recognition and assert themselves, close quotes. As we discussed earlier, the very norms, rules, and procedures for inclusion of Haiti in the name of universality shackled its aspirations for self-determination to debt bondage. If in a colonial era, integration into the world system was coerced, in the post-colonial era, neutral rules of recognition do their own work through a racial capitalist world system that invites inclusion as the inevitable articulation of self-determination. These derivative terms of membership have impaired and curbed the political horizon of anti-colonialism. We can situate reparation claims in sovereign debt's history of refusal, efforts seeking to unsettle the political futures inscribed into international law's terms of membership. For instance, consider the 1974 New International Economic Order and the NIEO's call for debt restructuring, or the 1985 call for a third world debt strike at the Tricontinental meeting. The call surfaced again in the shadows of Durban and reparation discussions leading to the World Conference on Racism, and then again in the Jubilee campaign for canceling debt and opposition to credit terms that entrenched long-term economic precarity. The international think tank, the Committee for the Abolition of Illegitimate Debt, has called for citizen audits of sovereign debt and its own subversion of international economic governance. In all these cases, debt severance is a form of refusal from being hailed as an international economic subject by international law, seeking to render the debtor subject ungovernable by the international economic order. Okay, let me close then by reminding us that the claims made here are not for debt forgiveness. Debt forgiveness implicitly legitimizes the underlying contract. In contrast, the doctrine of odious debt draws attention to the fundamental illegitimacy of international economic transactions. If debt forgiveness invests in a certain actuarial visibility, the doctrine of odious debt invests in a political visibility. Political visibility contributes to making resistance to the default post-colonial economic order thinkable, to use Michel Rolph-Truelow's term. Thinkability here is a kind of amicus curiae, a friend of the court brief, as it were, in a dissident lawyering case for the doctrine of odious debt as a framework for rewriting debt as reparatory justice. This legal legibility renders visible the process of invisibilization to better understand how that process inflects and inhabits history. At the core of a reparative claim is a status of the visible, and at the core of the legal claim about odious debt is a status of the fabula, what Saidiya Hartman refers to, following Mikebal, as the building block of the narrative. Insurgent legal claims stitch together doctrine and precedent, authorized interpretations and persuasive reinterpretations. With the hum of social movements and socioeconomic transformation as both impetus and inspiration, Amendment and reannotation are the building blocks of legal change. Legal concepts that were once errant and marginal may move to center stage. Settled interpretations may be rendered doctrinaire and out of date. You can see why the toy box is an appropriate metaphor for the indeterminacy of law and an understanding of the process of legal argumentation that is provisional rather than propositional, contingent rather than conclusive. This process can yield legal arguments that are innovative composites of the settled and the unsettling in ways that have resonance with what has been termed recombinant narratives. Hartman speaks to historical narrative that calls for a reconsideration of received interpretations by drawing attention to the essentially contested nature of the fabula and the narratives that provide their scaffolding. Her method of critical fabulation describes how we might engulf authorized speech in the clash of voices, and the ways in which she has tried to work with the archive to make visible, as she says, the production of disposable lives. This project requires listening generously for the fabula, imagining it differently, and then narrating it by rearranging, as she says, the basic elements of the story. This mode of bearing witness is part of what dissident lawyering also entails in formulating and advancing the doctrine of odious debt. Just as Hartman's history works with and against the archive, the legal argument for rewriting sovereign debt as reparations is working with and against the law. As we search through the toy box for recombinant legal narratives that offer different ways to refuse the rules of the game, a heretical imagination, and the invocation and rearrangement of basic legal concepts of contract and equity emerge as central to the work of interruption. The life of slavery and revolution, of legal claims about odious debt, and political briefs for delinking, these are all at the same time both a recording and a speculation about what happened and what might have happened in ways that open up what could happen. If the current world order continues to hurtle Haiti further into a long night of atrocity, the reparations claims and the story it narrates about how that world functions is like a modern Scheherazade tale, both true in its wisdom and fanciful in its ambitions, magical in its idealism and realist in its account of the lives and futures at stake. In drawing attention to the fact that we are all witnesses to atrocity, it seeks to forestall the futures that have condemned the formerly enslaved and colonized and redirect our vision to an alternative dawn. This reparatory vision interrupts the trajectories of foreclosure built into the law and logic of the international system through yet another story. It makes such alternatives seeable, thinkable, legally legible. In this, it follows previous storytelling interventions in Nights Past by Toussaint Louverture, Jean-Paul Aristide, and others yet to follow in the coming nights. Thank you.
Thank you, Vasuki. For very, very, very interesting. I thought was very insightful when I read it, and even more interesting when you hear it delivered in person. It's also it raises a number of questions, I think. And I think I want to ask one of the questions that I have to you first to start the conversation and discussion around, I think, what is a very critical legal perspective in terms of understanding reparatory justice. So my question, I think, to get us going is, what do you think is at stake and what are the limitations of current notions of reparative justice framed within an international human rights law perspective?
Sure, thanks, Kirsten. Yes, well, I think, the current current approach to reparations in international human rights law perhaps, is symptomatic of some of the concerns we may have about different elements of human rights law more generally, on perhaps particularly international criminal law as well. Firstly, it's an event-based model, right? You get reparations for egregious act, discrete perpetrators, discrete victims, rather than systems and structures. And there are some exceptions to this rule, but there's a basic model against which even the exceptions have to make their case, as it were. Sorry, should I continue? Yeah, so relatedly, for instance, it looks at perpetrators and not beneficiaries. Right? So it looks at, being able to, identify specific perpetrators and specific victims. We had, of course, in dealing with colonialism and slavery, there's a way in which there's a problem of temporality. There's sometimes a very practical problem regarding statute of limitations of particular crimes. And then there is the fact that it focuses so much on physical crimes, on deaths and disappearances, torture. That's in some sense a dominant history of international human rights law and reparations. And even when there is, and as often reparations, particularly following truth commissions, you get lots of, they're often led with preambles about how these are irreparable harms, but in fact, they push the arc towards a politics of closure, of closing the books. So there's a whole range of ways in which I think there are limitations to the current, the political stakes, the way reparations has been currently defined, that makes it ill-suited to think of along a historical durée, how that lives in the present, as well as in terms of thinking about systems and structures, not individuals, not discrete physical crimes, and so on. There's more to say, but perhaps that begins there.
Yeah, thank you very, very much for that. Thank you again, Vasuki, and we'll hear from you a bit later on as well, if there are more questions as they come along. So I want us to move to our second speaker, and I'd like to introduce Ralph Wild, Ralph is at UCL, University College London, where he convenes a course called Decolonizing Law, a critical treatment of the relationship between law and race, imperialism, colonialism, and post-colonialism. He explored some of these issues in his book, International Territorial Administration, How Trusteeship and the Civilizing Mission Never Went Away, in Oxford University Press. Ralph, on to you.
Thank you very much, Keston. It's a pleasure to be here. I'd like to thank warmly the organizers, both the administrative support staff and also the graduate student workers. Events like these don't organize themselves. We are in your debt. Now, as has been mentioned already, there's a strike happening at the moment by graduate workers at our host, Columbia University, and I'd like to express my solidarity with those strikers and to remind participants, I think this has been mentioned already, that the hardship fund for the strikers whose pay will be docked by the university while they're on strike. There should be a link, if there isn't already, posted in the chat. I'd also like to warmly thank Keston for giving up his time to read and comment on my paper and for generously doing so at such late notice. I'd like to start with the Greek fable of the dog in the manger. A dog who can't eat grain is inside the manger, the trough used to feed cattle their grain, thereby preventing those cattle from sustenance. This is commonly used, as in the quotation you can see there from Winston Churchill, as a metaphor for a situation where one person is preventing another from something the latter needs and which the first supposedly has no use for. Churchill uses it for a succinct and vivid articulation of two related things. In the first place, as a racist justification for settler colonialism, when this involves taking land from the indigenous inhabitants. This is permitted because of the race-based difference Churchill articulates between the settlers on the one hand and the indigenous inhabitants on the other. The former are a stronger race, a higher grade race, a more worldly wise race. Because of this, the indigenous inhabitants don't have the final right to their land, even if they may have been there for a very long time. And the racially superior settlers can take their place. In the second place, in consequence, since the taking of the land is justified, no wrong has been done. In his metaphor, Churchill provides a complete treatment of the subject of the normative character of colonialism and reparations for colonialism, a justification to the former and an associated repudiation of the basis for the latter. Churchill invoked his metaphor in the context of the 1937 Peel Commission proposal to partition mandatory Palestine into Arab and Jewish states. For Churchill, the Arab population in Palestine were the dog in the manger. Jewish migrants to mandatory Palestine, both at the time and those who would follow in the run-up to and after the Jewish nation state was established there, were the stronger race, a high-grade race, the more worldly wise race. Because of this racist distinction between the two, the Arab population had no final right over their land, and Jewish migrants could take their place. If this were to happen, which came to pass in 1948 with the creation of Israel in a significant part of mandatory Palestine, it would involve no wrong. Ever since 1948, and especially after 1967, with the occupation by Israel of the remainder of the territory of mandatory Palestine, when it comes to the question of where international state responsibility lies for Palestinian oppression, the denial of Palestinian freedom, the ongoing abuses perpetrated against the Palestinian people, this has been addressed primarily and even exclusively in terms of the behavior and responsibility of Israel. The position of other states has been typically addressed secondarily with reference to this Israel-centric starting point. Should they do more to push for the end to the occupation and call out Israel for its abuses? Should they adopt sanctions, for example, denying Israel the ability to trade, whether generally or at least as far as goods produced in settlements are concerned? Should they prosecute Israeli officials accused of committing international crimes, etc.? This approach ignores the fact that there is one other state where more direct questions of responsibility and accountability arise, the United Kingdom. As the administering authority in what became mandatory Palestine between 1918 and 1948, the UK implemented the policy set out in the Balfour Declaration of 1917. In that declaration, Arthur Balfour, the UK Foreign Secretary, stated to Walter Rothschild that, and I quote, His Majesty's government view with favour the establishment in Palestine of a national home for the Jewish people, and will use their best endeavours to facilitate the achievement of this object, end of quote. The UK enabled the realisation of this commitment by incorporating its terms as the overall objective of the Mandate for Palestine, the 1922 instrument adopted by the League of Nations Council that set out how the UK, as mandatory, was to administer mandatory Palestine. The UK then implemented this objective in practice. It facilitated Jewish-only migration to Palestine without a corresponding migration policy concerning other population groups, including Arabs, who were the overwhelming majority in the territory. This enabled a demographic shift in favor of Jews there. It provided for the transfer of land and property to Jews, including through compulsory expropriations and other confiscations from existing Arab owners or occupiers. It provided support for the development and establishment of provisional self-governing Jewish political institutions, while denying support to and suppressing the activity of any corresponding equivalent Arab institutions. Popular Arab dissent was violently and lethally suppressed, notably in the case of the Great Palestinian Revolt of 1936 to 1939, which was a nationalist uprising against colonial rule and the policy of enabling the establishment of a Jewish national home in the territory. With the onset of war between the Arab and Jewish populations in Palestine following the UN General Assembly adopting the Partition Resolution in 1947, the UK adopted a cut and run policy. It withdrew its presence in the first part of 1948. This paved the way for, and did nothing to stop and protect the Palestinians from, two related things. First, the creation of Israel in a significant part of the territory of mandatory Palestine that year. Second, the associated forced displacement of a large number of the Arab population from the territory that would form the basis for that new state, the Nakba. Palestinians demand a reckoning for what happened on two central grounds. In the first place, that it enabled their dispossession from their land and denial of collective self-determination through the creation of Israel in part of the territory of mandatory Palestine. In the second place, that the conduct of the administration by the UK was abusive and discriminatory towards the Arab population. 2017 was the centenary of the Balfour Declaration. This served as a reminder of the UK role. In Palestine, Mahmoud Abbas, the president of the PMA, announced in the year before that Palestine would sue the UK for the declaration. And no lawsuit has to date been forthcoming. The significance of the Balfour Declaration, however, is not so much in the declaration itself and its adoption in 1917. Rather, it's what happened in 1922 and thereafter. 22 is when the vision set out in the declaration was incorporated into the mandate. This transformed its provisions into an instrument with a different legal significance in international law, adopted by the Council of the League of Nations. It also expanded out the general objective of the declaration into a detailed set of objectives for colonial rule. Moreover, it isn't simply the adoption of the instrument that's significant. Also crucially is then how the UK implemented its provisions. When it comes then to the two Palestinian demands for a reckoning and the question of addressing what instrument is relevant to these demands, it's the mandate for Palestine of 1922, its adoption by the League Council and implementation by the UK that counts, not the Balfour Declaration itself. For this, of course, the key anniversary is next year. However, the common view of international law experts is that the period when the mandate for Palestine was adopted, there was no right of self-determination for colonial peoples. This came much later in the second half of the 20th century. Thus, it is said the Palestinians may have that right now, but they didn't have it then. In consequence, it said, the UK and the League of Nations Council, representing certain states collectively, had a free hand when it came to what approach they took to the question of the status of colonial territories, a free hand legally. If the UK and the League decided that all or part of the territory of Palestine was to be a national home for the Jewish people, including for the racist reasons set out by Winston Churchill, there was nothing legally impermissible about this. Such an account removes any international law basis for addressing the first of the two Palestinian demands for a reckoning. Equally and relatedly, it's also sometimes suggested that there were no international legal standards applicable to the conduct of colonial administration when it came to discrimination and abuses. Such standards that might operate only came later, with the adoption of international human rights law treaties in the second half of the 20th century. This removes any international law basis for addressing the second of the two Palestinian demands for reckoning. This approach to international law brings things back to the predominant contemporary focus on Israel. According to this account, the question of Palestinian liberation and a reckoning for abuses perpetrated against the Palestinian people is legally only a subject addressed by norms that came into existence after the creation of Israel. Israel may be bound by the international law of self-determination to end the occupation, and by international human rights and humanitarian law to end the abusive conduct of the occupation. And these areas of law, if enforced, could lead to redress mechanisms against the Israeli state and Israeli officials on an individual level. But equivalent questions relating to the mandatory period are, it is said, by virtue of the period itself, subject to a completely opposing normative position that rendered permissible, or at any rate did not prohibit, the equivalent practices of the UK and UK officials. This feeds into broader debates currently taking place in international law on the question of redress and reparation for colonialism. In these debates, a similar account is sometimes given to the account I've given of the Palestinian Mandate. International law facilitated imperialism and colonialism. It did not prohibit it, both colonial domination itself and practices associated with it. the enslavement of people, and other abuses and atrocities. A central strand of argumentation for contemporary efforts at redress has been to attempt to get around this intertemporal normative challenge by making the case based on ongoing effects and legacies. This temporal shift moves the clock forward into later periods of history when it is said international law standards became different. Others, such as Hilary Beckles, challenged the "it was lawful at the time" account of things, in his case when it comes to the enslavement of people in the Caribbean. As a complement to that work, my paper revisits the international law arrangements of the Mandate for Palestine and reevaluates the received wisdom here. I argue that the state of the law was quite different from how it is commonly understood. The League of Nations mandate system operated on the basis of Article 22, League Covenant, an international treaty forming part of the Treaty of Versailles. This contained two crucial provisions. First, the mandate in the former dominions of the Ottoman Empire, which included Palestine, there was supposed to be provisional recognition of statehood. In the second place, the mandatory was subject to a general obligation to protect the population in the territory during the period in which the arrangements operated. In my paper, I argue that the League Council didn't have the competence under the Covenant to vary these stipulations through the mandate, a document adopted in 1922. In consequence, the document provided no authority for the UK to depart from its obligations under Article 22, and insofar as the UK did this, it violated the Covenant and so the Treaty of Versailles. I then go on to explain how, as a matter of the jurisdiction of the International Court of Justice, a case on this subject could be brought today. So to finish, this work is obviously relevant to the ongoing calls for redress by Palestinians. But by addressing the specific situation of the mandate, I hope that it will also demonstrate the utility of exploring the general theme of reparations through case studies, where sometimes, as here, the particularities of the situations are at odds with what might have been the more general normative picture at the time. Thank you.
Thank you very much, Ralph. It raises a number of questions that I think are hugely important with respect to the Palestinian statehood and, you know, the importance of the relationship between colonizer and formerly colonized, or probably contemporaneously colonized, if we want to look at it in that way. So I'm going to take a liberty to ask you a question, if that's okay. And I know I'm going to ask you a question different from the one that I initially had sent to you, but I was wondering, how can the UK as a colonizing force and as an important actor in this particular case begin to come to terms with and grapple with its role in international law with respect to reparations in the case of Palestinian statehood? And I want to sort of frame this in the context of the UK itself having a sort of a somewhat nostalgic, but even sort of denial in terms of its role as a colonizing force, right? So there is that kind of ethos that the UK and, you know, governments in the UK deny to some degree its role in the atrocities that these communities face.
Thank you, Keston. So I thank you for your question. I should perhaps explain what prompted my involvement in this topic, which is that a few years ago I met with Raja Shahada, the great Palestinian writer and the founder of Al-Haq, the Palestinian human rights organization in Ramallah. And it was Raja who raised with me really the grievance that he and other Palestinians have about the mandate period and asked me what role international law might play in making the case for reparations. So the work that I then went on to do and the investigations I did was very much in response to that question by him, and of course became significant when the Balfour anniversary came up and the statement was made by Abu Mazen about somehow suing the UK for the Balfour Declaration. So I think it's very important to say, first of all, that my starting point was very much in response to the questions, the calls that were made by Palestinians. But you're asking me about, as it were, what this means for the UK. And so, I mean, I will answer that question, but obviously I do want to acknowledge that means that I kind of have to center the UK in this discussion, when this should be, of course, primarily about the position of the Palestinians and what it means potentially for them. So for the UK perspective, indeed, I think as is indicated in the slide that was put up for this presentation with the statue of Churchill, which of course during the movement for Black Lives protests last year was at a certain moment, there was graffiti written on it regarding Churchill's racism. And that statue and Churchill himself, in many ways, is a useful illustration of exactly the problems, Keston, that you identify within British contemporary politics and society about how the British, how we understand our colonial role, which is, I think you mentioned, Keston, denial, and denial is partly part of this. So an action like this would be really an effort to make people who deny this face up to what it is they're denying. It's also a question of ignorance and a basic lack of knowledge that's rooted in the way that education works in the UK. And I think that largely is part of the problem, requiring the British people to think differently about the fact that they occupy the position as one of the world's most economically privileged countries, and that came about at the price of the exploitation and abuse of other people, rather than simply because of the sheer ability of the British people, historically. And that requires the British people to think about themselves very differently. And so the stakes are very high in terms of, as it were, the national self-esteem of the British people. And that's the challenge, is to somehow, within British people like me, is to somehow seek to work to change those attitudes in a way that fights that narrative of excellence, and that the merit, the economic privilege that British people have now is deserved and is not based on unfair inherited privilege rooted in exploitation and abuse.
Okay, thank you so much, Ralph. I think obviously it's very critical, and I appreciate your comment. It's very critical that we center the experiences of the Palestinians and Palestine in this conversation as the injured actor, obviously, and the ongoing injuries that they face. I think I want to move. Thank you again, and hope we will get more questions for you later on. I want to move now to our third speaker and final speaker in today's session. And he is Dr. Ahmed Reed, who is a member and former chairperson of the United Nations Working Group of Experts on People of African Descent and Associate Professor of Caribbean History at the City University of New York. He received his PhD in Social and Economic History from the University of Hull in England. Dr. Reed's research interests and publications cover the areas of Caribbean and economic and social history, comparative slavery, the transatlantic trade in Africans and reparation. His latest publication, which he co-edited with Hilary Beckles and Vereen Shepherd, is a special issue on reparations in the Journal of Social and Economic Studies. Over to you, Dr. Reed.
Thank you. Sorry. Thank you, Keston. Let me thank Anna and Howie and the organizers of today's panel and for the opportunity, to address you on this very timely and important topic. So what I'm going to talk to you about today is around the 1920s, well, the 1920 Declaration of Rights that the Marcus Garvey-led UNIA issued, and a declaration which one does not readily find available or see in the general histories of human rights. And when you think about, in particular, the UDHR, which is widely celebrated. And so there are larger questions there as to what are the reasons for this historical silence around this declaration and what it contains. So let me just go right ahead into that in the interest of time. I've given it a larger framework there. 2020 was a challenging year. The killing of George Floyd has led many to call for an end to systemic racism and state-sanctioned violence against people of African descent. New global risks such as climate change, environmental degradation, and pollution have posed an existential threat to the lives and dignity of people of African descent. We have witnessed the onset of the COVID-19 pandemic, which resulted in the deaths of tens of thousands, mostly Black and brown people. The evidence before us is incontrovertible. Structural racism has further exacerbated the inequality in access to healthcare and treatment, leading to racial disparities in health outcomes and increased mortality and morbidity for people of African descent, We're confronted with the uncomfortable reality that racism, racial discrimination, Afrophobia, and xenophobia, and related intolerance pervades every corner of our global landscape. This curse continues to haunt the global community as the articulation of prejudice, the fomenting of racial hatred and intolerance, and the seeming justification and acceptance of racial discrimination continues unabated. We have yet to dismantle the ideological infrastructure of hate. Long-standing prejudices, the rise of far-right nationalism, ethno-populism, and nativism have resulted in growing incidents of racial discrimination. Racial prejudices resulted in strong anti-immigration backlash and the scapegoating of migrants and violence against people of African descent, often in plain view and with institutional and political endorsement. People of African descent continue to experience poor economic, social, and health outcomes and incarceration at vastly disproportionate rates globally. The recent calls for justice, racial equity, and an end to systemic racism are not new. What the events of 2020 have proven more than anything else is that the arc of injustice towards people of African descent is long and extremely painful. In 1920, some 20,000 delegates attending Marcus Garvey's UNIA convention in New York adopted what became known as the Declaration of the Rights of the Negro Peoples of the World. The Declaration stressed the relationship between the crimes of slavery and colonialism and the ongoing harm and injury to the descendants of enslaved people. It showed that racism, racial prejudices, and racial discrimination are deeply embedded in our historical past. Manifestations of racism are indelibly linked to periods of conquest, the trafficking and enslavement of millions of Africans, and the imposition of racial exclusionary laws, colonialism, and imperialism. For over 400 years, laws classified Africans and their descendants as non-human, chattel, property, and real estate, and social rhetoric and narrative evolved to rationalize, justify, and stabilize these injustices. Millions lost the basic right to their legal identity, and as such remained invisible in laws, legislation, and policies. They were denied recognition and instead subjected to the ideology of racism that demonized and denigrated all things Black and all things African. The cumulative effect is racial inequality, structural invisibility, exclusion, and poverty. Blacks, the Declaration asserted, are, and I quote, denied rights due to human beings for no other reason than their race and color, end quote. It continued, any law essentially directed against the African and singling him out because of his race or color is unfair and immoral, end quote. We protested, continues, and I quote, against the system of education in any country where Blacks are denied the same privileges and advantages of other races. I could go on and on, but as a member of the United Nations Working Group of Experts on People of African Descent that study and reports to the Human Rights Council and the General Assembly on the human rights of people of African descent, the issues raised in the Declaration brims with familiarity. We're confronted with the reality that people of African descent continue to suffer from many multiple, aggravated, or intersecting forms of discrimination. It is not far-fetched when I say that today, millions across the diaspora are asking the question posed by Ta-Nehisi Coates in Between the World and Me: how is it possible to live in a Black body? The Declaration was bold in its articulation of fundamental rights that were previously denied and which are still denied people of African descent. It stated that people of African descent are entitled rather to the equal rights of life, liberty, and the pursuit of happiness, and the right to even-handed justice. Put differently, it expressed that people of African descent have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms. The call for even-handed justice was a call to end impunity. More importantly, it centers on the right of people of African descent to security of person and protection by the state against violence or bodily harm. Violence or bodily harm includes ethnic or racial profiling, disappearances, extrajudicial executions, and torture. The goal then, as it is today, was to end the systematic and institutionalized targeting and killing of people of African descent. The common theme of the Declaration is the right to reparation. The preamble framed it best. This was against the wrongs and injustices they are suffering. Wrongs and injustices that were unrepaired in 1920. Wrongs and injustices that Blacks are experiencing 100 years later. and wrongs and injustices that literally and figuratively have disfigured Black people, Black bodies as well. The call for redress reparation was a reminder, especially to those who perpetrated these indignities on our ancestors and beneficiaries, many of whom are alive today, that we must address them through reparatory justice. Many of you have read the result of the research by the team from University College London that showed that Britain compensated its planters £20 million, or 17 billion in today's money, 50% of which stayed in the United Kingdom. Of the sums mentioned above, we know that enslavers invested in cultural institutions, built palatial country houses across Britain, invested in the railroad industry, among other commercial ventures, and invested throughout the empire. We also know that British banks such as Lloyds, Barclays, Royal Bank of Scotland, the Bank of England, and the now defunct Barings Bank all benefited from the exploitation of Black bodies in the Caribbean. The 1833 Act, therefore, that should have emancipated enslaved people, further solidified the racist interpretation of Africans and their descendants as property. No accompanying legislation was passed in 1833 to compensate the 850,000 enslaved people who suffered the trauma and humiliation associated with their enslavement. Many had high hopes and expectations of freedom. They had imagined the Caribbean society built on justice and equity, and one that would grant their children and grandchildren opportunities they were denied. What investments did enslaved people from Jamaica and other Caribbean territories make to realize their hopes and expectations of freedom, and more importantly, to secure a future for their offspring? We all know the answers to these rhetorical questions. And this is why the Declaration of Rights, as well as CARICOM 10 Points Plan for reparatory justice, are framed within the discourse of development. While Europe developed through colonial exploitation, the plantation system that they created defined the social and economic outcomes of Caribbean people. In plantation societies, race and class determines one's growth prospect. In the British Islands, let me read it again. In the British West Indian Islands, the declaration stated, Blacks are cunningly discriminated against and denied those fuller rights of government to which white citizens are appointed, nominated, and elected. Case in point, from the post-emancipation period onward, the newly freed people were thwarted by a colonial system that supported and facilitated land consolidation by the socially and politically connected white elites. Not given access to land, social and economic growth was difficult to attain by the citizenry. Resources sadly remained in the hands of a few. The edifice that colonialism created did not facilitate the development of the region's human and social capital. After all, that was not the intention. The Declaration calls for universal education and the protection of that right, which you can see in Article 30 of the Declaration. This was an acknowledgement of the poor educational outcomes for people of African descent. Poor imperial governance and the lack of imperial investment in the British colonized Caribbean is reflected in the low educational attainment of Caribbean people at independence. The colonial mess that Caribbean governments inherited was evident in the illiteracy rate throughout the region at independence. In Jamaica, for example, the rate was 60%. It was even higher in other Caribbean countries. The lack of access to education and widespread illiteracy subverted the development efforts of Jamaica and other Caribbean countries, which continues to be a drag upon social and economic advancement. The low economic growth the resulting poverty trap and the multidimensional poverty that we see in the Caribbean today are structural, with deep historical roots. There is no other way to say this. Exploitation of the region's resources have damaged the Caribbean's development prospects. This must be acknowledged, and the continuing harm of colonialism must be fully addressed if Caribbean people are to enjoy their right to development. It is for this reason that CARICOM has put forward its 10-point plan, which is aimed at repairing the harmful damages caused by European colonialism. As a conceptual framework, it will harness and strengthen the region's human and social capital and promote economic growth. I will close with these insightful words from Sir Arthur Lewis, the Caribbean's first Nobel laureate, who in his 1939 book, Labor in the West Indies, stated, and I quote, "What claim have the West Indies to demand such sacrifices from the British people? Briefly this, it is the British who, by their action in past centuries, are responsible for the presence in these islands of the majority of their inhabitants, whose ancestors as slaves contributed millions to the wealth of Great Britain, a debt which the British have yet to repay." I thank you.
Excellent. Thank you very much, Ahmed. I think it's very well received remarks and presentation. I am going to take the liberty of discussant and chairing this session to ask one question. So I think in your conversation, I think many of the historical ideas are well placed and well documented. I was wondering about the actual strategy or approach with respect to the CARICOM Reparations Committee and Commission and their framework for reparatory justice. Because at the moment it seems to be very state-centered and fairly top-down. I was wondering, what role do you foresee or envisage communities and popular movements or the popular sector playing within this process? And what are some of the dangers of excluding these communities and groups in the process that is very state-centered and one based on the idea of sovereignty?
Thank you for that question, Keston. I'll start by looking at the history of the reparation movement, which you go back and you look almost immediately at the point of well, toward the ending of enslavement. You'll begin to see historically the demand for reparation, for reparatory justice. The Moran Bay Rebellion was a demand for repair. Paul Bogle and those freed people wanted to repair the society, the consequence, of the legacies there. You go to the Marcus Garvey UNIA movement, again, a call for repair. You go to the 1930s throughout the Caribbean, 100 years, sorry, after emancipation. Again, a call for repairing those anti-colonial rights. You move to the 1960s and Rastafari, the same thing. So the reason why I started this way is to show that the idea of the movement being top-down, it's not really a top-down movement. It has always been a grassroots movement. What you have had over time is, for the movement to go forward, yes, you need buy-in from leaders and from governments. And so what you see is an amalgam of forces at this point. So it is not, really a top-down movement per se, but a movement which has always been a grassroots movement, where you have coming on board over the last 20, 30 years, academics and in particular member states, CARICOM states. And that is important. For those who operate in the global arena, you know it's important. If discussions are going to be had, it must be member state. So it's important to have leaders on board and countries on board. What you also see as a result is since 2013, 2014, when CARICOM at its heads of government meeting in Trinidad decided to form the Caribbean Reparations Commission, chaired by Professor Beckles. One point is to encourage member states to form national reparations committee. And that again in itself is to get grassroots buy-in and support for the movement. So I think it's an amalgam of forces which is necessary, that you have all the right stakeholders that are now coming together at the right time, at the right moment to advance the cause for reparation.
Okay. Thank you, Ahmed. I appreciate your response and I appreciate everyone's comments. I have a slight question in follow-up to to your response. And then we will move to more questions. I didn't want to lose the momentum of the question because I think it's directly related to what you just said. So I think I appreciate the history, the historical origins of reparatory justice and the importance of those struggles and movements in reaching the point that we are at now. I think to consider at least over the past 30 or 40 years, and we consider the history and context of neoliberalism having a hold on the Caribbean region and the globe as a whole, we need to consider the fact that many of those movements and struggles are not as active in the current dispensation of reparations and not as considered as important when we consider the perspective of the state in the Caribbean and the perspective of sovereignty as an important anchor of reparations at the moment. So I want to sort of, if you have any further comments on considering, you mentioned it's an amalgam of forces, but I want to suggest perhaps it might be a culmination of forces that we have at the current moment for reparatory justice, whereby the state is currently in the lead in that respect. And I want you to see if you have any reflections on what might be the risks with respect to moving forward from that perspective.
Yes, well, food for thought. Culmination of forces is equally apt as well, Keston. What they, you know, with every movement, there is some fear, and I understand the point you're making regarding it being state centered. It is the reality though of the international system in which we work. When you look at it, for example, for those of us who have experience, particularly with the UN and the UN system, if it would be impossible for a grassroots movement to approach a member state on an issue as important as reparation or reparatory justice. So it's vitally important that we have, and there is buy-in from member states. What we, the concerns that you have, and there are concerns, and rightly so, but what we can do to address these issues is to continue what we have always done, to educate even our leaders as we go forward with the claims, educate our citizens as widely and as broadly as possible, because yes, there are people in the Caribbean with pro-colonial sentiments. It's just what it is. So to suggest that, and you know, that everyone is on board with this, not the case. So the road ahead is one of education, one of advocacy, one of going, you know, whatever platform to put the case forward and as best as possible. But as you rightly say, the culmination, and I like and I rethink it, it's important now, because when you have looked at it over the years, I think since CARICOM has joined the discussion, it has taken on a different dimension than before. In now the fact that you have member states that have gotten together, that have formed a regional commission led by Sir Hilary Beckles, and are now, and I think some CARICOM states have written to former colonial powers. So there is momentum there. So the concerns are there, and I accept that. But we need these member states of CARICOM. It's an important thing, and you see this. I think it was in 2013 that the National Reparations Commission in Jamaica, when they issued some recommendation, one recommendation was that in moving forward, the reparation movement needed to extend beyond just activists to try to get the sort of buy-in from member states. So I think they're moving in the right direction.
Okay, great. Thank you so much, Ahmed. I think we want to move to some other questions that have come through, and offer the opportunity to the two other panelists. So we want to thank all three of you. Thank you very much. I know everyone may be knocking their screens or clasping their hands in appreciation. So thank you all three of you for giving very insightful and very informative presentations. We really appreciate it. So one question that has come in the chat is from a member of the audience who has asked if the panelists can say, if they can respond to this, to what extent is it ever possible to move beyond event-based conceptions of reparation within frameworks that international law provides us? Is there a possible legal process that would not privilege the singular event? So perhaps we can have, because we haven't heard from her for a while, we can have Asuki give a response, please.
Yeah, thanks for that. Yeah, I mean, you know, the one way of thinking about it, and perhaps this actually resonates with both Ralph and Ahmed's presentation as well. One way of thinking about it, and where we have had some discussion, is, of course, you know, even if you look at the Truth Commission processes around, you know, in Guatemala, in, you know, less so in South Africa, that remained primarily event-based, but in Guatemala, in Peru and elsewhere, although you had in some sense a combination, you had a focus on events, and certainly it was, you know, that was what people came and gave testimony about. But you also located those events, and certainly the commission reports located those events in the history of colonization, or in the history of genocide against indigenous people, and so on. So there is a way in which you can do that, and of course, even in international criminal justice processes, so the ICTY, for instance, looks at the ways in which ethnic cleansing becomes systemic, the way in which it gets incorporated into bureaucracies and so on in the former Yugoslavia. So that there are particular ways. I mean, it's all lead up in some sense in those cases to an event. But there's also a recognition that there's a structural, or there is a way in which these events are knit together in ways that that cannot be captured except in those contexts. And certainly the Truth Commission report, which of course allows a bit more, allows more space to have a broader historical analysis, do that. And even in South Africa, which was extraordinarily event-based, all the public hearings were event focused. I mean, the commission, of course, could not. I mean, you cannot understand any of those events without situating it against the history of apartheid, colonization, and racial capitalism. Even though they did not actually, in some sense, they consistently narrowed it in terms of defining reparations, and made the distinction between people who are victims and people who are beneficiaries. And reparations was given to people who were classified as beneficiaries, people who could come before the commission and situate things. And then there have been examples also. I mean, I think the case a few years ago from the Mau Mau going through the English courts, those were again event-based, and it was in addressing the problem that I mentioned earlier. It was shaped by questions around physical harm, survivors, all of those things, but again could not make sense except against a backdrop of colonization. So there is a way in which I think one can rethink international law differently going forward, and so that things that were backgrounded can be foregrounded. It's a question of context in some sense and how we make those arguments. And in a sense, part of my intervention was to try and open up that possibility, so that even though it is the event that where there is in fact so much precedent and such a long history, there is a context in which one can do that. And of course, the biggest example of reparations is what Germany did post-Holocaust. So that again, cannot be understood except in systemic and collective terms. So I would argue that although it has not been what international arguments around reparations have focused on, there is that possibility, and the ways in which we think about colonialism, not as something in the past, but as something ongoing, is of course central to both, I think, the situation that Ralph was discussing, the situation Ahmed was discussing, and I see in the chat even how he's questioned the idea, and that's how certainly, First Nations communities in the US see settler colonialism as something we are confronting today, not something that happened 400 years ago alone.
Okay, thank you very, very much. Any comments, Ralph, of moving beyond event-based?
Yeah, I mean, well, one way, of course, is that even when any specific event ends up being addressed, often actually because the event was part of a broader structural process that was happening in many different places and was legally enabled, if we think about the role of international law, by common international legal arrangements which operated in many different contexts, then what we find is that sometimes when the specific event ends up being addressed, by default, the broader structural arrangements have to be considered, because the specific event and its legal consequences, including for reparations, cannot be determined without reference to the broader normative framework, for example, in international law, that may have played a role in enabling that process, right? So if we think about the mandates arrangements, and we think about, and there's been a question about this in the chat, when efforts were made to challenge South Africa's continued presence in what was originally called Southwest Africa, later Namibia, when it refused to withdraw from that territory, of course, until 1990, and was so maintaining it as a colonial dominion, but also implementing the practice of apartheid within Southwest Africa. The efforts that were made to try to challenge this internationally before the International Court of Justice, which there were individual cases brought by certain states, and there was an advisory opinion by the International Court of Justice, the Namibia advisory opinion. That opinion by the court had to address the question of self-determination as it related to all of the mandates. Not just the specific situation of the Southwest Africa mandate. And so actually, in the event, what we get is a treatment of the general normative framework as it related to an entire class of colonial territories, the mandate colonial arrangements, and also, indeed, more generally, the significance of self-determination. So sometimes the particular can be a way into the general.
Okay, excellent. Thank you very much. I'm looking at more questions, and I'll bring Ahmed in on another one. Let me see. For Ralph, this is for Ralph and Vasuki. Thinking on a broader scale about claims to redress, can you say more about the kind or different kinds of pressure, various forms of international claims to redress, for example, Palestine or the Caribbean, place on international law?
Do you want to go first, Ralph, or do you want to go?
So sorry, what was the question? What do they do for international law?
If you can say more about
I can't see the question.
Kinds of pressure, various forms of international claims to redress placed on international law.
What pressure they place on international law?
I'm supposing the questioner means what is probably at stake with respect to these claims for international law. How perhaps the different forms of claims. So if there is a specific claim to redress, either in the case of Palestine or the Caribbean, what is at stake for international law in this respect?
So maybe this could be situated within the broader politics of international law and the role that it can play in relation to redress generally, right? So not just in the historical, in relation to historical abuses, but in relation to ongoing situations. And indeed, that is a system under pressure. And so there is a challenge here in terms of seeking to circumvent political failings. So if we think about the UK situation, right, the unwillingness politically of the UK to respond favorably to these challenges to reparations and to seek to circumvent that through legal fiat in some form of legal determination by an international court that would, as it were, force the UK to face up to something that it is unwilling to do. And the stakes there, of course, are very high when it comes to the expectations that we can reasonably place on international, well, on law generally and international law in particular, to be able to deliver on that. And one thinks about the efforts that are made in Palestine, which are described sometimes pejoratively, depending on people's perspective, as lawfare, to seek recourse to international legal mechanisms because the political process has failed in the context of the profound power imbalance between the Palestinian people and the Israelis, and the seeming unwillingness on the part of other states who could to put pressure on Israel when it comes to the question of vindicating the rights of the Palestinians. And law has been recourse to legal mechanisms, becoming part of the Rome Statute for the International Criminal Court, Palestine ratifying a whole suite of international human rights mechanisms. Palestine, of course, now attempting to bring a case against the US before the International Court of Justice in relation to the US embassy move to Jerusalem. All of these efforts, of course, are attempting to try through law to achieve what hasn't been possible through other means, through the political process, because of the problems I've mentioned. And there is a question, of course, as to the ability that law has to deliver in that context, and what that says about the problems of the broader processes that international law is used in this sort of last resort fashion, and how sustainable that is as a mechanism, quite apart from the broader questions, of course, about the legitimacy of addressing situations like these through legal means at all, which has to be retained as a critique, even if they are somehow recourse is being used to them and understood in some sort of pragmatic way.
Okay, Vasuki, any thoughts?
Yeah, sure. I mean, I think, on the one hand, international law and law in general usually cannot lead on these things. Usually it's social movements that lead on these things. So, when Ahmed speaks about, the different ways in which CARICOM builds a particular momentum, that's certainly important for, what possibilities we pursue through and whether it's through and against international law in different ways. So one way certainly is in terms of social movements, and I think and certainly court cases are one possibility, and sometimes court cases are the result of social movements, and certainly we have had many cases that have gone through international courts that have been processes that have worked alongside social movements, often social movements in the lead around a whole range of these things. I think the Mau Mau case is one of them. Certainly the case on the wall in the ICJ is another one. On the wall in Israel is another one. There is a whole range of, for better or for worse, kinds of international developments around gender and justice that have gone through the international courts that are very much a result of feminist organizing outside of courts. So I think if one thinks of law as not confined by the four walls of the courtroom and the directions of the law itself in some broader context, then I think law is potentially all that, and potentially that as well. The World Conference in Durban certainly was one opportunity where you could see intersection of many actors: international law, states, social movements, a whole range of groups, and for a whole range of the forces against reparations were also organized, and they defeated those efforts. But that's just one example. I mentioned in my talk in sort of passing, in 1985, the Tricontinental moved for a debt strike, to the extent we're thinking about debt as a form of reparations. That also didn't succeed. But I think of these as, I think of these kinds of struggles as an iterative process. We are constantly winning some, losing some, and the struggle goes on, as it were. So it's not a once and for all move of international law bringing closure on these things, but international law is one of the many terrains on which the struggle continues.
Excellent, thank you so much. Let's see more questions. Any comments on the question with respect to Ahmed, with respect to event-based claims, or any that we've asked so far? Let me see. Trying to navigate this on a mobile phone is a bit of a challenge.
It's okay, Keston. No, I don't really have a question or comment. Sorry, a comment on that. I have a question for Vasuki though, but I'm wondering if I'm allowed to ask fellow panelists questions at this point, or I should just wait until you go through your broad
Perhaps.
list of questions. So I'll wait. No, I don't have a comment on that.
Okay, excellent.
So I'll save mine for later.
All right. Let's see. I think we do have one question for you. Let's see. This one is for you. Is there any specific law that addresses land rights for indigenous peoples in Africa, traditional communities such as the Quilombos in Brazil or the Maroons in the Caribbean?
Sorry, could you repeat the question? Are there any
specific law that addresses land rights for indigenous people, either in Africa, Brazil, or the Maroons in the Caribbean?
I speak to the Caribbean in particular as it relates to the Maroons. I'm not 100% sure. What I do know about the Maroons, though, is it goes back to that 18th century agreement, which they made with the British. So this issue of land rights and the right to ancestral land, broadly speaking, in the Caribbean, I can't speak to any legislation. I don't think there is any. I'm just jogging my memory here, because I know there was a commission of inquiry along those lines in Guyana in 2016 or 2017 on the issue of land rights and ancestral land. So I cannot say for sure that there are any beyond what I know about the Maroons and their 1739 or thereabout agreement that they made with the British, and the Maroons have since then remained some level of autonomy, if you will, as a result of that.
Okay. Let me see. All right, so perhaps this is for everyone. How can we distinguish between the kind of work in international human rights law and international law, respectively, can do or cannot do for claims to redress historical injustices? So what capacity does either international human rights law has or international law has with respect to redressing historical injustices?
Yeah, I can have a stab at that. So my sense is it has a lot of capacity that hasn't been used. So as we would wish in some sense, but also there has been movements that I think movements in terms of the use of law that I think can be grounds for pushing it in a whole range of different directions. So international human rights law is, on the one hand, historically the dominant tradition has been very much individualist and focused on individual harm. But there have been important, for instance, changes in that around collective harm. I mentioned the Truth Commissions earlier and reparations coming out of that. So in Peru, in Guatemala, in a whole range of places, and people were asking about land rights earlier, there have been movements and there have been reparation policies around restoration of land. land claims of indigenous communities that were displaced during the war and so on. So I think there are ways in which, and of course it's difficult, on the one hand, those may have a particular time frame of the civil war in Peru or in Guatemala as their reference point, but of course those were not really civil wars. Those were, one way to understand those wars are also as settler colonial wars, or at least the latest iteration of settler colonial wars. And in that sense, you can see those as, coming in a long history of these efforts. And there are, for instance, recently in Canada, in response to the stolen children, stolen generation issues, there were, on the one hand, you saw a combination of, individual reparations given to people who were individually harmed, plus some collective effort, collective efforts that are now part of Canadian law, that are in fact speak to that history, that speak to the longer durée that enabled the stolen generation issues to emerge. So I think it's about, I think there are lots of resources within international human rights law. There'll be a lot of resistance as well. So, it's, I think, it's a particular historical conjuncture where the fight is being fought in some sense, and what are the political, and it requires analysis of those political forces rather than sort of broader generalizations about, what's what is the way in which to proceed on these things. But so in particular context, then one can see how particular kinds of arguments could work. And particular ways in which framing the historical, the questions of temporality could where human rights could be mobilized in particular ways. Although, as I said, not without resistance, but nevertheless.
Okay, excellent. Any comments with respect to the capacity of international law or international human rights law? Ralph?
Yeah, thank you. So, as Vasuki said, arguments can be marshaled around the temporality issue that could potentially therefore bring ongoing legacies from a historical period under the purview and applicability of human rights law, which of course was adopted at a particular historical moment. But there's another challenge, of course, which is the very applicability of human rights law, human rights treaties, to the relationship between, one state and another state, right? So there's a question of the temporal applicability, but there's a question of the spatial applicability. And this is another area of law that I work on more in relation to contemporary situations, but also in the historical context. So the conventional position here is that human rights law only applies extraterritorially. So between, for example, the UK and a state that is was previously one of the UK's colonial territories, therefore establishing a normative legal relationship between the two that could form the basis for reparations. That's only, so as I mentioned, there's firstly the temporal question of ongoing legacies, but then spatially, the conventional view is that anyway, those treaties don't apply extraterritorially. So for example, the UK to Palestine, or the UK to any other states in the Caribbean, for example, in the context of those claims, unless there is a relationship of extraterritorial effective control. So ironically, the very relationship that, of course, was brought to an end through decolonization is, and which enabled these abuses to happen, is the very type of relationship that contemporary human rights law requires to exist before the obligations are triggered. And even extraterritorial obligations understood on that basis are challenged by states. So there is very much a resistance to states to be bound by obligations on that basis. So we think about states that engage in the kind of extraterritorial activities that would bring them potentially raise these questions. So the US, Russia, the UK, Israel, certain other European states, they challenge it even in a even on that basis, right? But the idea that in some other way there would be operative human rights obligations applying extraterritorially would require a complete departure from the existing jurisprudence in human rights law.
Yeah, okay, thank you. And I'm wondering if any of you have questions for each other. So if you have any questions for each other, you can ask them now.
Yeah, I have a question for Vasuki, and I was listening on your presentation about Haiti and what happened almost immediately after Haiti gained its independence and the stranglehold. When you look broadly at the history of reparations and looking at it broadly, you know, a lot of times the focus tend to be on Germany in that context, or even before that, on the 20 million pounds that the British paid enslavers for the loss of their quote unquote property. But would you classify the Haitian payment to France started in 1825 and ended in 1947 as a form of reparations?
I wouldn't, but you know, of course, there are people do, and I mean, I wouldn't because, you know, for political reasons that I wouldn't want, you know, I think it would be conceding too much. I would think we should instead call it, you know, call it what it is. It's call it robbery or call it something, you know, a particular kind of theft. We shouldn't call it reparations. And I think the battle over how we name these things is part of what it is, right? So that's partly the question of whether we name debt as debt or whether we name debt as, you know, a different form of theft is, you know, part of what's at stake. So I think naming is really important, and there's a lot at stake in that. So I wouldn't call. So yeah, so that's my that's my sort of quick answer to that. I mean, I think you know what we need, and what Aristide, for instance, was asking for is reparations for that theft, right? So that there is a way in which France needs to take account of the fact, or, you know, as Britain does, for the fact that it rewarded slave owners and rewarded itself for you know, for a genocidal practice, and that it needs to, and therefore it owes Haitians as of course Britain owes the Caribbean. So. You're muted, Kirsten.
Not hearing.
All right. Sorry about that. Any response? Ahmed, did you have a response?
Yes, I understand the point, Vasuki, but all I'm thinking about it is the Haitian government at the time had to borrow money from the you know, private banks and banking institutions in France, and that money went to enslavers. So the principle of reparations, therefore, in the same way that Britain paid enslavers or compensated enslavers to the tune of 20 million, in the broad scheme of reparations, then that's how I'm looking at what Haiti paid to enslavers as, put it if you will, enslave or reparation, if you want to call it that. But I mean, I take your point for political reasons, but I was just looking at it within that larger context.
Yeah, I mean, I don't think we should concede the British one either. I mean, I think that too, we shouldn't call it compensation. We should call it, you know, it's basically a political payout to get the planters supporting imperial Britain policy and its decision at that point that its economic needs, as Eric Williams would had argued, were better served with imperialism than slavery. And this was, in some sense, what we would now what we would describe as sort of poke in a national budget. I think there too we should contest it.
Okay.
Thank you all very, very much. This was very, very interesting, insightful for me. I learned a heap. I want to now invite Anna to formally close this very, very, I wish we could go on and on, but unfortunately, all good things come to an end, right? So Anna, please, can you come on and help close for us, please? Thank you.
Yes, Dr. Perry, thank you so much. This has been quite a terrific last 2 hours. Thank you everyone as well out there for seeing you again and for hanging in there. There's just one last question here from Julie Skursky at CUNY, who's asking if there are Hispanophone countries that have made claims for reparations in the Caribbean or elsewhere. And I want to use the opportunity to flag that next week, we have another panel coming up entitled Epistemologies of Repair, with presentations from Saira Simone, Nicole Imler, Joanne Scott-Lewis, and Rosalina Armange. And there are at least 3 Caribbeanist experts who will be able to respond to this question. So Skursky, Dr. Skursky, I invite you to come back. And to anyone with interest in the matter, please do return. And so thank you for everyone for coming and for engaging the panels. The session has been recorded and will be made online, will be made available online, my apologies. And so more information soon, and see you Wednesday. Thank you, everyone.
And thanks for having me, and thanks everyone.
Yes,
thank you.
Panelists.
Take care, everybody.
Thank you.
Bye.
Thanks.